We are good.
All right, you're alive.
Okay, beautiful. I'll call this meeting to order then. So this is a meeting of the City of Bangor's Board of Assessment Review. So good evening, I'm the chair. My name is Ryan Collins. We're here to consider a court remand by the Superior Court of our decision dated March 9, 2023, which decided the appeal of the Arthur J. Keenan and Cynthia S. Pelzer individually and as trustees and beneficiaries of the Arthur J. Keenan and Cynthia S. Pelzer Trust of 2016. This concerns the denial of their application for a Maine homestead property tax exemption for their property located at 20 Savage Street, designated by the city as account 005544, tax map 023, lot 030 on city assessment records. Our hearing this evening will proceed generally as follows. I'm currently making a statement of some of our issues and going over our outline. We'll move to opening statement from the petitioner, should they like to offer one, followed by any presentations and exhibits. From there, similar, we'll move to an opening statement from the respondent, should they like to make one, followed by the presentation of witnesses and exhibits on their side. From there, we'll move to a rebuttal from the petitioner, then rebuttal from the respondent, then we'll move into argument by the petitioner, and then argument by the respondent. Finally, this board is a little different in a sense that we do deliberate. We come up with findings of facts and a decision sort of in this same setting. So we will be deliberating and deciding this issue this evening. So after each witness then tonight has made their presentation, board members and then the other party can ask questions of that particular witness in that order. So board members present this evening are myself, I'm Ryan Collins. I am currently the elected chair. To my right is Mr. Dean Beaupain, who is the elected vice chair. And on my left is Mr. George Burgoyne, who is a regular member of this board. I will just mention that per the board bylaws, a quorum of this board is present this evening, where we have 3 or more regular members. I will ask briefly on either side, are there any immediate objections to the composition of this particular panel?
None.
Nope. Okay, perfect. Okay, so just operationally, but our hearing this evening is being recorded. We're also obviously live on Zoom or video technology. So for that reason, really only one person could speak at a time. So for that reason, I'd ask then that we turn on the microphone when speaking at the podium. There's a little bar, a little button that you hit to do so. And then please turn it off after, just so that there isn't crosstalk or something getting lost that way. I will mention also this evening, this proceeding is sort of a first for this board, where it did come to us via remand. The board tonight is also represented by Mr. John Hamer, Esquire, who's here just to help us procedurally and just ensure that we don't miss anything. Obviously, we need to get this right, and admittedly, we're in a little bit of unfettered waters. So, John, thank you so much for what you do. Okay, some issues before us this evening, which we need to address specifically as a part of the remand are the following. We need to understand who the owner is of real estate located generally at 20 Savage Street in Bangor, Maine. That being determined, we then need to consider if Arthur J. Keenan and Cynthia S. Pelzer, not individually but as trustees of the Arthur J. Keenan and Cynthia S. Pelzer Trust of 2016, are owners of said real estate located at 20 Savage Street, Bangor, Maine. Therefore, if they are found as trustees, if they're then entitled to a homestead exemption as owners of this property. In addition to that, we need to determine if Mr. Keenan and Ms. Pelzer as beneficiaries of the same trust of 2016 are then owners of real estate located at the same address. And therefore, if they are beneficiaries, if they're entitled to a homestead exemption as owners of that property. So those are the two primary questions. We did ask in the scheduling letter, and just for public's benefit, some very specific questions, which we felt necessary to render a complete and accurate decision. We have, again, just noting, we'll get there in a minute, but received responses on either side. So tonight, we're really trying to focus more on either of the questions that we asked in sort of our outline here, where those are central to our decision. For this evening, this is not a courtroom. I'm just mentioning because there are an awful lot of lawyers here. So I'm not a judge and we're not jurors. Questions tonight, points of order, should be addressed to myself as chair. I will mention that any evidence having reasonable probative value will certainly be admissible. However, without the technical rules of evidence and objection and the like, but subject to the requirements of due process, which was notification and the like. Anything that's determined immaterial, irrelevant, or for example, unduly repetitious, out of scope, will be excluded this evening. Again, we have some very specific questions to address from the court. At this time, are there any immediate or preliminary matters that the party or the board should address or deal with prior to proceeding this evening?
Mr. Chairman,
Mr. Vice Chair.
I would like to distribute some deeds.
Okay.
One of our primary objectives tonight is to determine the owners of the property.
Merci.
And I think these deeds will help us document and decide that issue. Only one of those, what I've attached is the declaration of trust from the registry, and that is already in the record.
Okay.
The next document is the deed from Mr. and Mrs., Arthur Keenan and his wife Cynthia, to them as trustees of the 20 Savage Street property. And then there are two mortgage deeds from the trustee. I think both of them run to KeyBank. And those are the only documents really that I found that shed any light on this. And unless, does anybody have any objections to making those part of the record?
And they may very well.
No objection, I think some of them may already be part of the record.
Okay, one of them is, yes. I didn't see the others. Mr. Keenan? Do you have any?
No objection.
Okay. So given that, we'll enter these into the official record. On that, I will just mention, but the prior record that includes the order from the Superior Court obviously has been provided to this board, and it will be a part of the record for this hearing, just because it's material concerning the appeal. So that's part of this package that you see in front of us up here, and obviously copies provided previously. But just noting for the record that we do have that, and we would be considering that order. That's part of the reason that we ask the questions and are trying to focus in the direction that we are tonight. Other preliminary matters? Council, do you have anything?
No.
Perfect, okay. So at this time then, Mr. and Mrs. Keenan, would you please identify any witnesses that you may have so that they could be sworn?
We have no witnesses.
Okay. Will you be offering testimony yourself?
I'm not sure.
Okay.
Initially, I didn't intend to, but there is something I want to address that may need, it's kind of been assumed. I don't think it appears in the record,
Sure.
so.
Okay, so I think given that then, why don't we swear you? I think that would be the safest bet. And council, do you object to that? Does that make sense?
Sure.
Perfect. Then, Mr. Drew, would you please also identify any witnesses, or counsel, would you please identify any witnesses so that they may be sworn as well?
Mr. Chair, we'll just be offering legal argument tonight.
Okay?
Yeah.
And is that you then, Mr.
That
Brown?
would be me.
Okay, perfect. Well,
That's
so-
why I'm here, yeah.
Okay. So we do need to swear, why don't we swear you as well, Mr. Bauer, along with this? So would you both rise then?
I guess an attorney's not able to offer testimony, but in case we have questions for Mr. Drew, maybe it makes sense to have him sworn.
Sure, let's do that. Beautiful. Thank you. So if you would, raise your right hand, answer me truly. Do each of you solemnly swear or affirm that the testimony which you are about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, under the penalties of perjury?
I do.
Beautiful, thank you. Please drop your hands and be seated. Okay. So we will now then proceed with our hearing this evening. Again, outline, we would start with a presentation by the petitioner that would include an opening statement, witnesses, and basically anything that you'd like to offer at this time in opening. Mr. Keenan.
In general, my view is that I've said, I believe, everything that needs to be said about our status as trustee and trustees and owners. This is a document that I remember we have still a home equity loan, it's almost done with. It's interesting, this is something that we didn't draft, rather it was given to us by Key Bank. And I do see it's of interest, never thought of it at the time, that was, when was that, 2016? Let's see, 13.
The short-term mortgage,
Right,
Mr. Keenan.
the home equity loan, 2000, okay, that was April 16th, 2018, apparently, when we signed it. I think it's interesting that, that we were called upon to sign it only as trustee. But I don't think it makes a difference because, first of all, the bank needed our signature as trustee. Technically, we should have also been identified on the mortgage as equitable owners. It wasn't done that way. That was not even an issue that occurred to me until this business came about. So that's interesting. We didn't draft the document. Yes, we signed it as trustee and not as an equitable owner.
Mr. Chairman,
Mr. Vice Chair.
could I ask Mr. Keenan a question?
Please.
Did the bank determine that you as trustee was one of the owners of the property, and that's why?
I have no idea what the bank was thinking.
But you signed as trustee?
I have to, because this is a mortgage, what's the word I'm looking for? Maine is, in order to get a mortgage, you have to give the bank the deed.
And the bank thought they were getting title to the property.
Well, they did, because as trustees, we do have the title in our name. It's a bare legal title, but it's there.
And the
because-
authority to mortgage the property. That's a
Yes,
specific
and-
power.
Yes.
Yeah.
But we were also there in person. We were thinking of ourselves as just, we assume, in order to get a mortgage from a bank, you've got to haul in all of the people that you need. At the time, we didn't think of the division between title and equitable owners. Now that all of this has come up, it's obvious.
Do you, as trustee, are you required by the trust instrument to consult with you as beneficiary over whether to sell a piece of trust property?
that question is obvious. What is less obvious
Well,
is this.
if it's so obvious, tell me what it is.
Maybe you could restate your, because I'm not, it
All
seems like you
right,
asked the same
let's-
question and I
let's
answered
assume,
it.
let's call the trustee person one, and let's call the beneficiary person two. Does the trustee person one, is he required by the trust instrument to consult person two, the beneficiary, before the trustee sells a whatever piece of trust property that the trust has?
True.
Does not have to consult?
True that, I think you asked the question in a way that doesn't the trustee have to consult? As a matter of fact, it's my view that because we are the owners, and
Could
we,
you-
although
Could
we
you point
also,
me to the section of the trust that says the trustee has to consult with the beneficiary? I didn't see it in there.
yes, it's there, and
Well, can you get out the trust instrument and find it?
I can tell you, the language in the trust, without having to dig through stuff, because it's thick to dig through.
No, I have it right here.
Good. Dispositive provisions, paragraph 2. The trustee shall hold, manage, and invest the trust property for the benefit of the settlors. We are the settlors.
All right, I'm asking you if to sell a piece of trust property, holding it for the benefit of the beneficiary, including the proceeds of the sale, are you required to consult and get the consent of the beneficiary?
As I said before, I think it's the other way around. The trustees cannot do that on their own because their job is to serve the lifetime beneficiaries and then the remainder beneficiaries.
Well, what if the trustee decides that they will get a better investment for the beneficiary by selling a piece of trust property?
Still can't do it. Why? Because it's our home.
And you're talking about that specific paragraph says you have to consult?
Well, it's because it's implied, it's obvious.
Well,
It's obvious.
I'm,
The trustees are not serving the interests of the beneficiaries without collaboration. They can't. They can't just do that on their own.
well, you'd agree that the trust instrument does not specifically have a provision requiring the trustee to consult with the beneficiary.
I disagree. I just read it to you. There's more, but I just read it to you. That is the kernel. They cannot do that. If it's for our benefit, they necessarily, and that's why I say you've got it a bit backwards, because we are the owners. We have to consult with the trustees if they're interested in doing what we'd like them to do. They have a veto power. We show up in person, that means we're there individually. We sign the trustee's name, we're giving the bank the title they want as part of the home equity loan.
But it's a trustee who signed. It was a trustee who signed the mortgage.
Right, and as I said, that's all they needed the title, we gave them the title. It makes no sense that we didn't consult ourselves. It just doesn't make any sense.
Well, you created that.
No.
You're the trustee, the settler, and the beneficiary.
No. Well, we're talking about the mortgage now, and I didn't create that. Nor did I think of all of these issues in the context. This is a complicated case, I think you might agree.
Well, it has been. I would agree with that.
I think I've answered your questions. Do you have any more?
Just give me back my copy
Yes.
of the instrument. Thank you.
Okay, anything further, Mr. Vice Chair? Okay, Mr. Keenan, please, we were working through sort of an opening statement or anything from witnesses, so please.
I don't really have an opening statement. I rely on the stuff that I've written.
Sure.
And I'm sure you've read it.
I have.
So,
Or what was pre-filed.
right,
Yes.
but the thought that occurred to me is, and we've made maybe it's already covered. We've made representations. We have made representations. They haven't been objected to but for example, I don't know if there was any formal sworn testimony, which we don't mind giving today, as to the fact that the residence is not an income producing property.
I think that you meet all the criteria other than whether or not you qualify in your position as trustee, as an owner under the statute. I don't think there's any question it's residential property, you occupy it. And there hasn't been a lot of talk about that because we accept all that from the record.
I think then I'm ready to pass the microphone.
Okay. Thank you. Was there any other questions? Hang on, Mr. Keenan, please, from the board to Mr. Keenan. Okay. Typically at this point then, we would allow the something from the respondent.
Sure it is. The green light means it's on, correct?
Yeah, green means go, yeah.
Thank you, Mr. Chair. It's been a bit since I've been in front of the board, and I appreciate the opportunity to present tonight on this appeal. As you pointed out in the outset, we're here because the Superior Court had remanded the case back down to you and actually vacated the prior decision. The court had taken issue with the finding of fact that the property was owned by the trust. Now, I find that finding to be understandable given what was in the record, so I don't fault the board for making that finding. The deed of the property was to the trust itself, not to the trustees. The court pointed out that under Maine law, a trust is not a quote-unquote juristic person. And so wanted to send it back down for some clarification. And I think both the line of questioning that you provided before the hearing and your questioning tonight and the documents that Mr. Beaupain provided, I think are helpful in that regard. I think although the procedure here is a little bit complicated, I think overall the general issue is not. The question is really whether the property that's held in an irrevocable trust qualifies for a homestead exemption or not. I mean, that's really what this all boils down to. And then there's obviously the ownership question on top of that. But I think I would like to just reframe, because of the fact that the decision was vacated, I think you're going to have to readopt either a new or an amended decision. I think it's helpful just to reframe, the issues under the statute, because I think that also lends itself to the conclusion that they're not entitled to the homestead exemption. Homestead under the statute means any residential property owned by an applicant or held in a revocable trust, a revocable living trust. Because the property at issue is held in an irrevocable trust, as has been established, not a revocable trust, the property doesn't qualify. This makes sense because, as I pointed out in my pre-filed comments, an irrevocable trust is treated differently than a revocable trust for tax purposes. It is treated as an entity that's distinct from the person. And I pointed out the example that an irrevocable trust has its own EIN or tax identification number because it's treated as a separate tax entity, while a revocable trust is not. A revocable trust, if you have one, is treated as a pass-through. Essentially, it's disregarded for tax purposes. And so I think, and as I'll get to later, when there's been some more recent legislative work on this issue, it's clear that was the intent behind that statutory provision, is that the revocable trust is included in there because of the fact that it's disregarded for tax purposes. The next important definition is applicant. Applicant is defined as an individual who has applied for a homestead property tax exemption. Arthur Keenan and Cynthia Pelzar do not own the property in their individual capacities. Even despite what they provided in their pre-filed testimony or the pre-filed comments that they said that they own it in their personal capacities, it's owned in their trustee capacities. That's clear from the mortgage documents that have been provided and the deeds that have provided, and the fact that the action in court was brought by the trustees on behalf of the trust. The trustees are the owners of the property in their capacity as trustees, not as individuals, and that's important on the statutory definition. Now, the questions that the board raised, I think were good ones and were thorough. So I'd reference my memo just from October 11th that sort of went through those questions. And if there are any questions about that, I'm happy to respond. But I think those kind of speak for themselves. But overall, I think what I would like to do is in summary, that I think the questions and the answers that we provided on behalf of the city assessor were helpful to draw the distinction between ownership in an individual capacity and ownership in a trustee capacity. And I think, again, that's what really is at the bottom of this. Ownership of a trustee capacity can still qualify for a homestead, provided it's a revocable trust. So there, again, it's less about, what you want to call it. It's more about whether it's a revocable or an irrevocable trust for the reasons that I mentioned before. Now, I think the board was not privy to the argument at the Superior Court, but one of the arguments that I raised at the Superior Court was that the remedy for the taxpayer is a legislative one. They can go to the legislature and seek an amendment to the statute that would allow for irrevocable trust to qualify for a homestead exemption. And in fact, the legislature has just recently considered a proposed amendment to the statute. So I'd like to provide, just for the record, a couple of documents that I think would be, helpful on this question. One is the legislative document or the bill that dealt with this issue. And I just would offer this into the record.
Thank you.
It's legislative material, but I think it's not technically. And then the second is some testimony that was provided by, at the legislative public hearing on it by the Associate Commissioner for Tax Policy for the state of Maine, Mr. Michael Allen, that I thought was helpful on the question of, and I will call out some of the highlights that I in this testimony.
Thank you.
So this goes to the question of, in my view, what the legislature was intending. And so, as you can see, in 2023, a bill was introduced in the legislature. This was after your board's decision and also after the appeal to Superior Court. So none of this would have been, you wouldn't have had the benefit of this the last time around, and maybe it's been helpful if it had been introduced by then. But the bill sponsor starts from the premise that the property that's held in an irrevocable trust is not eligible for a homestead exemption. I didn't provide the testimony from the bill sponsor, but that was the gist of the proposal. So what the proposal was to change existing law to allow for irrevocable trusts, recognizing that they don't qualify currently under current law. The committee, though, voted to kill the bill. They voted not to pass, and it's no longer pending. It never made it out of committee. So the testimony from Michael Allen that I provided, and I wanted to call out some, and obviously as, Associate Commissioner for Tax Policy is well familiar with these issues. He says, quote, generally, income and estate law recognize property held in revocable trusts established by the homeowners for their benefit as effectively owned by those people. And then he says, another quote, conversely, income and estate tax law align with Maine property tax law in not recognizing an individual who lives in a homestead that is held in an irrevocable trust as the owner of that property. And he makes reference to other tax exemptions, the veteran exemption and the blind exemption, that also specifically call out revocable trusts, not irrevocable trusts. And so his other point, aside from the fact that the tax law generally does not recognize irrevocable trusts as being property that's owned by the individual living there, that this change in law would cause problems with those other tax exemptions that do also, make that reference to revocable trusts. So I think just to get to the question of what did the legislature intend by this, the language that's existing, is that I think it couldn't be clearer that they did not intend to have irrevocable trusts included in that homestead exemption, because they specifically considered a proposal to allow for it, and they turned it down. So the taxpayer arguments, I just wanted to make reference to a few of the arguments in the materials that were provided. Page 2 of the supplemental filing, quote, every aspect of a revocable trust and the property held by that trust is the same as the settler's exclusive property, which is why the grantor's social security number is used for tax purposes. And then he says an irrevocable trust is not personal to the grantor. So I think that, again, the taxpayer's own words sort of draw that important distinction between sort of why did the legislature draw this distinction between revocable and irrevocable? For that reason, for the reason that a revocable trust is treated as their property, whereas an irrevocable trust is not. And they're separate, obviously very good estate planning and tax planning purposes to put it in an irrevocable trust. They made that decision to do that instead of a revocable, but they can't have it both ways. They can't have both those benefits, but also the homestead exemption, at least under current law. Pages 6 to 7 of the supplemental filing, quote, it is unclear what the legislature had in mind when it crafted the homestead statute. I think based on, sort of the more recent bill and so forth, I think that we can be assured as to what the legislature's intent was. It was to not include irrevocable trusts in that exemption. And then pages 6 to 7, I just wanted to point out sort of the remedy that the taxpayer is requesting. He says, we request a rebate in an amount equal to the difference between the taxes paid during the years we were denied the homestead exemption and the amount we would have paid had we been granted the exemption, in addition to being included in the exemption going forward, as well as other benefits made available to owners since this matter was appealed. I just wanted to point out, those are not remedies, even if the board were inclined to side with the taxpayer on this appeal, those are not remedies that the board can provide. There's only 1 year that's before the board, and that's the only remedy that can be provided. As you pointed out, Mr. Chair, you're not a court of law able to provide, remedy beyond the year that's being appealed. So I just wanted to make that one point in terms of the remedy, to the extent that the board were to side with the appellant here. So I just wanted to sum up, I think there's no question, and there can be no question, that irrevocable trusts are disqualified from homestead exemptions under current law. The ownership here, I think to answer the court's question, the ownership is in, Mr. Keenan and Ms. Pelzar in their trustee capacities, not in their individual capacities, and as a result, simply do not fit into the statutory structure for a homestead exemption. I think that's been made clear. And I think also the legislature has spoken on this question as to really what their intent was in dealing with irrevocable trusts. And it's clear that they were really wanting to limit that trust issue to just revocable trusts, where those are sort of treated as one and the same as the taxpayer itself. And then I just think I'd like to just again touch on the documents that have been provided by the board into the record. Those mortgages, signing as a trustee is significant. I think it's significant that the beneficiaries do not have to sign a mortgage. It's the trustees are the ones that are signing the mortgage and conveying that interest. I don't believe that the trust document anywhere requires the trustees to confer or get permission from the beneficiaries. That would be sort of counter to how a trust is supposed to work. The trustee is supposed to act in the best interests of the beneficiaries, but is not taking direction from them, especially for a spendthrift trust. It only needs to, these documents only need to be signed by the trustees in their sort of as the owners in their trustee capacity, not the settlers, not the beneficiaries. And I think so. For those reasons, I think that sort of just highlights the fact that, along with your questions and the answers to the questions, that there's an important distinction between ownership in a trustee capacity and ownership in an individual capacity. The latter is entitled to a homestead exemption, the former is not, and so that's where we are with this particular property. Happy to respond to any questions if the board has any.
Okay, does the board have questions for Mr. Bauer and
Mr. Chair, if I may.
Mr. Hammer?
So
Floor is
Mr.
yours.
Bauer has provided 2 documents to the board, and I presume it's being moved into evidence.
Well, I would make a motion to admit into evidence the pre-filed filings of the 2 parties, a supplemental filing by the plaintiff, the deeds that were presented tonight, and Mr. Bauer's copy of legislation and the position of Maine Revenue Services on that legislation.
Okay,
Second.
it's been moved and seconded then that we accept the various materials that were presented this evening, along with the pre-filed material formally into the record, and thank you, probably blew right by that. Is there discussion? Okay, seeing none, those in favor, I will vote.
Before you do that,
Ooh,
if I
okay.
may, you should probably
Mr.
ask the,
Oh, yeah, we should check, so, you're up, for the, respondent, are there any immediate objections to any of the pre-filed material?
No,
Or material submitted tonight?
no objections.
Beautiful, Mr. Keenan?
No objections?
Beautiful, okay, seeing none, discussion, seeing none. Those in favor, raising the right hand. Okay, to vote, we will enter then into, the record, the pre-filed materials and the various materials that were presented this evening. So, thank you, done. Beautiful. Questions from the board, and then typically the.
I just have one question.
Yeah.
Mr. Bauer, do you think that the bank felt they were getting complete title to the real estate when they took a mortgage from the 2 trustees?
Was the bank acquiring the complete title to the
Yes.
property?
So that if there was a default and they foreclosed, they could sell all of the real estate?
Indeed, yes, I do.
Thank you.
And I believe they thought that too, when they were giving their mortgage. And I'm sure they were advised that they only needed the trustee's signature in order to make that document enforceable.
Right.
Mr. Bauer, while you're up, but
Yeah.
one thing, and admittedly was writing and reading, and I like may have lost in this, but the other sort of track this evening was just concerning the sort of beneficiaries of the trust. So what would the respondent's position be concerning the beneficiaries of said trust, and the applicability then, if they are so entitled to a homestead exemption? Maybe I missed that in the memo.
I
There's the other
think,
track of
well, I
question.
think, I think some of your questions sort of got to this point, I think, a little bit in the 17 or 18 questions.
Right.
But I think one of our responses was basically that, the beneficiaries of the trust are not the owners of the property. The owners of the property, in our view, at least, are the trustees in their capacity as trustees. And so, the beneficiaries, they can't convey the property, they can't mortgage the property, the creditors cannot touch the beneficiaries that's sort of part of the deal with the trust, right? You shield yourself from certain liabilities, and that's I'm sure a part of why the appellants wanted to put it into a trust. But the flip side of that is that because there's not then individual ownership, and it's not a revocable trust, they become disqualified for the homestead exemption. So it's sort of, it's the flip side of the same coin, I guess would be a way of looking at it. But, yeah, so hopefully that answered your question.
Thank you, I think just maybe a little lost in everything up here, so.
Yeah,
that's
there's been a lot of paper files on this one, but.
Okay, thank you. So, at this point then, we are at,
Well, does anybody have anything further to add?
sure, yeah, we can go for that. Anything further then on the side of the petitioner?
A brief response.
Sure.
Okay, hopefully I can keep it brief. Opposing counsel pointed out that, that irrevocable trusts don't qualify because they're treated as a distinct person. The problem with that approach is that it is taking the concept of estate, gift, and income taxes as a controlling means by which ownership occurs, and that's just simply wrong. There is no connection between tax EINs and the ownership that's involved here. The revocable trust is disregarded for tax purposes because that is a creature of the settlor, who is the trustee, who is the beneficiary. And the thing that's important there, in fact, a trust, a revocable trust and an irrevocable trust can read exactly the same, except for the fact that the irrevocable trust declares itself as irrevocable in order to be that way, otherwise it's presumed to be revocable. And the revocable trust doesn't even have to mention anything. It just, that's the presumption in the law. So, and the important thing about a revocable trust is it's entirely personal to the settlor. He can go in and he can change the beneficiaries, he can pull in or pull out assets, put other assets in. He can do anything he wants with a revocable trust. You can't do that with an irrevocable trust because the settlor is committing himself to this is where my property is going after we're gone. I'm not taking that back, it's there. There are more than just two basic bodies of individuals. There may be three, but really there's technically four. One of the things I mentioned in the irrevocable, in my, I don't remember, it was the supplemental or my initial argument. I'm sorry, my brain just.
Yep. Take a minute, that's fine.
Right, so we as trustees will soon enough step out of that role and have other trustees in our stead for a variety, and those trustees are likely to be, most likely to be, unless there's some reason I can think that it wouldn't work, our children. So that when we get older and grayer and less competent, whatever, they still, as our children, will work to keep us in the home. If it doesn't work out, then they have, as trustees, the power to sell, use that money accordingly. But in addition to all of that, the court is part of what an irrevocable trust is, because until there are, I'm not going to get into what the trustee can do on his own and what the court can do. Every one of those instances requires a look at the statute. But for the most part, I feel relatively comfortable in saying that whatever's going to occur in a change of the trust, it may not apply to trustees at the moment, I don't have an answer to that. But whatever happens to an irrevocable trust has to have the consent of the remainder beneficiaries, likely the court, just so the court knows what's going on. It's not in that sense, the irrevocable trust is not personal to the settlor. Even if the settlor is the trustee, the beneficiary, the lifetime beneficiary, you've got a fixed remainder beneficiary, and then you need a court to say, okay, is what is being proposed consistent with the trust? Is everybody truly on board? Let me back up with one other thing involving creditors. the uniform code says that creditors can reach every asset that's distributable to the beneficiaries of the trust. Okay? In that sense, it's no different, really, than revocable trusts in terms of not being a bar to creditors. The thing that makes our trust a problem for creditors is the spendthrift clauses. I don't know how that would work in a revocable trust, but but I think it doesn't make any difference, because the individual who created that and runs it, they can do anything they want to do. They could, if they had a spendthrift provision, it probably wouldn't even be applicable, because it's like someone standing in front of a creditor saying you can't have that because it's mine and I say it is. Once the trust is, and by personal, I mean, everything about the revocable trust is in the power of the settlor, always, all the way through. And that's not the case with the irrevocable trust. But none of that has anything to do with ownership. It's just the nature of the trust itself. The fact that the statute refers to individuals does not thereby mean that we are not eligible as individual owners in an equitable ownership capacity, even if we also wear the hat at the same time of the trustees. And I may return to that, but let's move on for just a moment to the proposed legislation. Doesn't apply. That particular proposal that was poo-pooed by the legislature should have been, because a lessee by definition is not an owner. We are an owner. You can't, the whole point of a homestead is to, even if it's a life lease, doesn't change anything, they are not the owner. You don't have a lease if you're an owner. You don't lease to yourself. You lease to someone else. I don't want to miss thoughts that I had here. The whole idea of calling the trustees the owners is bizarre, I guess, is the best, because the very nature of a trustee is that they are not owners, except for the title. But as I put down in my brief, I mean, what is an interest in property? An interest in property is an ownership. And title is an ownership, but as I explained in my briefs, bare legal title isn't an ownership. So you can call it an ownership. This is where it gets kind of fuzzy. You can call it an ownership, but it's not really. As the case that I cited calls it, there's more than a few. It's bare legal title. Their interest is not as an owner. It is as a depositary of the title. They hold the title. They don't have any ownership interest in the title. They hold it for someone else. That's why it makes no sense for the idea of a trustee owner just doesn't add up. I don't know of an instance how that could be done so, unless, even then it doesn't. The trustee does not hold the property for themselves. It's that simple. They hold it for someone else. If they have an ownership, a true ownership in that property, not just as a depositary, there's a conflict of interest there. I'm not sure how that would apply, tell you the truth. Ownership interests are always the same. The ownership interest, let's talk for a moment about revocable trusts. Either there is a revocable trust in place at the time of the assessment of taxes, or it's not, because the settlor has revoked it. So let's assume that at the time of the apportionment and assessment, the settlor has left the trust in place. The whole nature, as you know, of property tax, not income tax, but property tax, it's a constitutional based beast. And in order for that to work, I'm sorry, I'm losing my thread here. So at the time of the apportionment and assessment, the revocable trust is still in existence. And let's say it reads exactly as ours does, right to the T, except it doesn't have that provision in there that says this is irrevocable. Otherwise, it reads exactly the same. The irrevocable trust and the revocable trust still have the same ownership, exactly. You have the revocable trustee, the revocable beneficiary, same as what we have. Except because it's personal to the revocable, I won't go down that road. Let's just examine these two trusts side by side, A and B. A is revocable, B is irrevocable. The ownership interests of the parties are exactly the same at that time. I'm not sure how far I want to take this, but on paper they're the same. And the reason I say I'm not sure how far, because it's personal to the revocable trust is personal to the settlor. It may be. I think we can say this, because despite the fact that it's ignored for property tax purposes or other tax purposes, doesn't change the fact that the ownership on paper is exactly the same as the ownership in an irrevocable trust. And whenever you read anything about revocable trusts, being ignored or being treated as that of the owner, fine, I don't disagree with that. But on paper, they have the same interests as the owners of the irrevocable trust. And that's what we're comparing. We're saying that as equitable owners in fee simple, we are in the exact same place, not just on paper, but because the irrevocable trust is not treated as personal to the settlor. The ownership interests are the same, except for the fact that the revocable trust is treated for tax purposes and otherwise as it's personal to the owner. That's why the Social Security number of the settlor is used, even though it's still in trust. And that's what we're comparing here. You can't lose sight of ownership. And a trustee who has complete control of the ownership trust of the property in all respects and the trust, it would be a sham if that revocable trust, in fact, was not treated as the individual's own property. So the analysis that I have given before about how it's determined what interest is passed to the trustee, starts with what interest is passed to the beneficiary. And then what's the purpose of the trust? And then the trustee is given only so much interest in the property as that person needs, or that the person in that position of trustee needs in order to fulfill his duties under the trust. The trust, as I've said before, has no income. Without any income, most of the trustee's duties that can be assumed, but certainly not yet, he doesn't have any ability to do it. There's no way that the trustee, who doesn't have income from the trust, there's no way he can do his job. All of this is assuming that at some time in the future, when he needs to have that power, he will get it because of incapacity, whatever it might be, of the beneficiaries. In other words, as the common law cases read, the active trust and the passive trust can flip-flop depending upon circumstances. At the moment, it is a passive trust, not an active trust, because the trustees can't, as a practical matter, do anything. There's only so far you can take this business involving the mortgage that was signed only by the trustees. Again, we didn't do the document, we wanted the home equity loan. We obviously signed as trustees. How can you not say that an individual who wears two hats didn't confer with himself about what needed to be done or what they desired to have done, and the trustee accommodated them? I don't think I left anything on the table here. Thank you.
Okay.
Thank you.
Thank you. And we'll move to our respondent for anything for.
I have two quick things, and one of them was brought to light by the fact that I realized I copied the wrong legislative bill. There were two sort of companion bills that were introduced at the same time in that legislative session. One dealt with life leases, and the other dealt with removing the revocable designation on the homestead exemption. I only have one copy of that one. It's LD number 149. So I'll just show you that.
That's all right.
I'm gonna offer that. I just printed the wrong one, made the multiple copies of the wrong one. So I'd like to offer this as well, and if that's all right.
I make a motion to admit LD 149 into the record.
Second.
149?
149. So basically what that, oh, sorry.
Yeah, let's get that in there,
Yeah.
because again, I end up forgetting. So, moved and seconded that we admit, this is, legislative document number 149, into the record. Is there objection by the petitioner?
No objection.
Okay, discussion from the board. Seeing none, those in favor signify by raising the right hand. Okay, LD 149 is in here.
Thanks. And just to summarize, I mean, all it really does is it was a very simple bill. It was proposing to strike out the word revocable so that it would allow for any living trust to qualify for a homestead exemption. And that, the testimony that I provided from the Maine Revenue Services actually addressed both bills because they were sort of considered at the same time by the legislative committee. But really, the one that's more germane to this appeal is that LD 149, which was proposing to take off that revocable designation, recognizing that irrevocable trusts do not qualify for a homestead exemption, and the legislature summarily rejected that proposal. So that just was that point. I did want to clarify, I don't think I said that an irrevocable trust is a distinct person. A trust is not a person, and I hopefully didn't say that. My law school professor would be very upset with me if I were to say that. The point that I was trying to raise was to explain why the legislature drew a distinction between a revocable and an irrevocable trust. And that was, in large part for the reason that Mr. Keenan just, said. He said, quote, "Revocable is entirely personal to the settlor." And that's exactly the point. It's ignored for property tax purposes. It's ignored for income tax purposes. It's disregarded, whereas an irrevocable trust is not disregarded. And so that's the distinction. Legislation has to have a rational basis, for drawing distinctions in order to survive a potential constitutional challenge. Luckily, you as the board do not need to deal with that particular question. I noted that he has raised a constitutional argument, but the rational basis that the legislature is drawing here is that one is personal to the settlor, as he pointed out, and one is not. One is disregarded for tax purposes, and an irrevocable trust is not disregarded. So I just wanted to make those two quick points and provide the right document that I meant to provide before. So thank you.
Thank you very much. Okay, we're at sort of a summary argument from either side, and it seems like we've gone over it. We feel the need for anything further on either side? Go ahead, you got it.
I just mentioned the constitutional issue, but because of what was said, I think this is something that needs to be stressed.
Well, Mr. Keenan,
Yes.
last time around, we determined that we are not a body with authority to
Agreed.
overturn
Right.
statutes because they violate the Constitution. We have to take the statute as passed by the legislature. So I don't mean to interrupt you, but
No, listen, I appreciate that. You will do what you will do. But what gets lost in the shuffle here is ownership. This isn't about this shouldn't be about trusts. Like the statute says, when you read it, it says the independent clause says owner. Then you shift to the dependent clause and it says, or if the beneficiary, I forget exactly the language, but it mentions benefit. It doesn't say title, it doesn't say anything else, but if the person who occupies that place as their permanent residence, etc., having the beneficiary interest, an ownership interest.
Mr. Keenan, in my previous life, I was a real estate attorney for over 40 years. The number of transactions I have done with trusts is, over the years, fairly common. I never had any problem accepting a deed from a trustee as conveying the entire title to the real estate we were dealing with, or mortgaging the entire title concerning the real estate. Some of this was residential property, some of this was commercial property, various kinds of real estate. So I understand your ownership argument. As one member of the board, it is overly complicated. I go by what's in the registry of deeds, okay? If there's a deed to a trustee, and then I see a couple of mortgages from the trustees to a bank, that's pretty clear to me who the owner is. The owner is the trustees. Now, your ownership is limited by the terms of the trust agreement, no question about that. You're still the owner, subject to those restrictions. And the legislature has drawn a distinction with respect to this exemption between a revocable trust and an irrevocable trust. And that's the only thing I had any difficulty with until Mr. Bauer was kind enough to provide us with this legislation that tells us two things. Number one, the position of Maine Revenue Services, apparently since this statute was enacted, was it doesn't cover irrevocable trusts. And the second thing is, the legislature took this subject up after our decision and decided not to change the statute. So, I'm certainly willing to listen to your argument, but you don't seem to be
Yeah, and I feel the same way. You're not listening to my
I
argument.
apologize for that.
No, because of the way you're approaching it, you're somehow failing to comprehend what I'm saying.
Well, we're all-
I'm relying on the common law very much. I'm relying on the statute
Well, we're
very
not a
much.
common law state, we have the uniform trust code.
The code says that unless some statute displaces it, and none does, the common law supplements.
I agree, the
And
problem is,
so you need to look at the common law.
the legislature passed the trust code. It includes a definition of revocable trust. They then passed the exemption statute and used the term revocable trust.
And what's puzzling is it makes no sense.
Well, maybe the legislature does things that make no sense,
And for
they
that
passed the
reason,
law, that's all I
and
can
for
tell
that
you.
reason, we still have a constitutional law problem.
And that's beyond our.
I
reach.
agree, and I'm not trying to make you do something that I wouldn't do if I was in your position. I'm just saying that there's a lot of work here that has gone unthought of, even in your 40-year career. These are issues that I haven't thought of until my homestead was
I
taken
have
away from me.
read and considered very seriously everything you submitted to this board.
And it's not a position that you can accept as a board member because of the statute, and I understand that.
Right.
Thank you.
Thank you. Okay. That concludes argument. This would, at this point, be deliberation phase. Again, a little different in the sense that we do that in this proceeding. This portion is for the board and by extension, board's counsel. We need to consider findings of fact where that was part of this remand decision of
Do
proceeding.
you want to discuss this, or I'd like to make a motion concerning findings of fact?
Okay, well, let's entertain a motion then concerning findings of fact.
I make a motion that the board find the following facts based on the record before us and the testimony and presentations we have heard. Number one, Arthur J. Keenan and Cynthia S. Pelzar, in their capacities as trustees of the Arthur J. Keenan and Cynthia S. Pelzar Trust of 2016, are owners of the real estate located at 20 Savage Street, Bangor, Maine, based on the records in the Penobscot County Registry of Deeds, and specifically on the deed to them in their capacities as trustees, recorded in Book 14207, page 163. Number two.
Before you go on to number two, perhaps we should take them one at a time.
Okay.
Okay, so then it was moved that we adopt the finding of the, who are the owners then of the property as finding of fact number one. Is there a second? Seconded. Is there discussion about finding of fact number one? I have nothing. Okay, seeing none then, board members, those in favor of adopting that as finding of fact number one, raising the right hand. Okay, that's done. Finding of fact number one. Thank you.
Mr. Chairman, I make
Mr.
a
Vice Chair.
motion that the board find the following fact based on the record before us and the testimony and presentations we have heard. The rights of ownership of the 20 Savage Street real estate of Arthur J. Keenan and Cynthia S. Pelzar in their capacities as trustees of the Arthur J. Keenan and Cynthia S. Pelzar Trust of 2016 are subject to and restricted by the Declaration of Trust of the Arthur J. Keenan and Cynthia L. Pelzar Trust of 2016, hereinafter the trust instrument, which is recorded in the Penobscot County Registry of Deeds in Book 14084, page 280.
Great.
I'm sorry, I missed some of that. It didn't quite add up to me. Would you mind saying it again?
Not at all. The rights of ownership of the 20 Savage Street real estate of Arthur J. Keenan and Cynthia S. Pelzar in their capacities as trustees of the Arthur J. Keenan and Cynthia S. Pelzar Trust of 2016 are subject to and restricted by the Declaration of Trust of the Arthur J. Keenan and Cynthia S. Pelzar Trust of 2016, hereinafter the trust instrument, which is recorded in the Penobscot County Registry of Deeds in Book 14084, page 280.
Thank you.
Okay, is there a second?
Second.
Okay, seconded that we, moved and seconded then that we adopt that as finding of fact, number 2. Is there discussion? Seeing none, those in favor raising the right hand. Sounds good. Okay, Mr. Vice Chair, were there other findings of fact?
I make a motion that the board find the following fact based on the record before us and the testimony and presentations we have heard. Arthur J. Keenan and Cynthia F. Pelzar, in their capacity as trustees of the Arthur J. Keenan and Cynthia S. Pelzar Trust of 2016, have exercised their rights as trustees in the real estate located at 20 Savage Street by mortgaging the real estate as owners by mortgage deeds recorded in Book 14779, page 30 on April 6, 2018, and Book 14802, page 44 on May 4, 2018.
Great, is there a second? Okay, moved and seconded, we adopt that as finding of fact number 3. Is there discussion? Seeing none, those in favor, raising the right hand. Okay, that is finding of fact number 3. Okay, thank you. Mr. Vice Chair.
I make a motion that the board find the following fact based on the record before us and the testimony and presentations we have heard. Pursuant to the terms of the trust instrument, Arthur J. Keenan and Cynthia S. Pelzar, as individuals, are beneficiaries of the trust property during their natural lives.
Okay, is there a second?
Second.
Okay, moved and seconded, we adopt that as finding of fact number 4. Is there discussion? Seeing none, those in favor raising the right hand. Okay, that is finding of fact number 4. Mr. Vice Chair.
I make a motion that the board find the following fact based on the record before us and the testimony and presentations we have heard. Pursuant to the terms of the trust instrument, Zachary J. Keenan and A. Jack Keenan, as individuals, are beneficiaries of the trust property upon the death of the last of Arthur J. Keenan and Cynthia S. Pelzar.
Okay, is there a second? Okay, moved and seconded, we adopt that as finding of fact number 5. Is there discussion? Seeing none, those in favor raising the right hand. Okay, down hands, thank you. That is finding of fact number 5. Mr. Vice Chair.
I make a motion that the board find the following facts based on the record before us and the testimony and presentations we have heard. The trust instrument, by its terms, is not revocable, as that term is defined by Title 18B MRSA Section 103.13, and is, by its terms, irrevocable, as that term is defined by Section 13 of the trust instrument.
Is there a second?
Second.
Okay, moved and seconded that we adopt that as finding of fact number 6. Is there discussion? Seeing none, those in favor raising the right hand. Great, down hands, thank you. Mr. Vice Chair.
I make a motion that the board find the following fact based on the record before us and the testimony and presentations we have heard. Arthur J. Keenan and Cynthia S. Pelzar, in their individually and as beneficiaries of the trust instrument, the Arthur J. Keenan and Cynthia S. Pelzar Trust of 2016, are not owners of the property for purposes of Title 36 MRSA Section 681.2, the definition of a homestead.
Okay, is there a second? Okay, moved and seconded, we adopt that as finding of fact number 7. Is there discussion? Seeing none, those in favor raising the right hand. Okay, thank you. That is finding of fact number 7. Mr. Vice Chair.
No further proposed findings of fact.
Okay, that gets us the findings of fact. We're still in deliberation at this point. Was there anything else that we needed to add? We should check with council too, but Mr. Vice Chair.
I think that I made my views known
You did.
in the discussion with Mr. Keenan. And once again, I think it's very significant that the legislature considered a change to the statute for the exemption and the definition of a homestead after our decision. And we now have record evidence that, number one, Maine Revenue Services has consistently, apparently, felt that irrevocable trusts are not covered by the homestead definition. And of course, obviously covers revocable trusts, so why would they have put that in without it? And of course, the second thing is the legislature considered the change and decided not to make it.
I'd just offer, a couple thoughts and excuse the lack of legalese. The bird brain here is kind of swimming, but, one immediate concern that comes to mind is to your point, Mr. Vice Chair, the direct wording of the statute. I think in this, if for some reason that, this was approved or the like, we'd be establishing a precedence. And I think along with that, possibly in an area that we all seem to be somewhat uncomfortable with, kind of taking the temperature or reading the board here and trying to follow along. So one other thing that comes to mind is, potentially just because you can, doesn't mean you should. And I think that we as a board need to be careful to use a narrow definition, specifically looking at where we are, looking at the scope. This is the City of Bangor's Board of Assessment Review. Said differently, we're back to sort of some of the original issues that were raised previously, but were the actions, for example, of the respondent in this case reasonable, given the variety of information, that we have in front of us. And I keep coming back to the statute and that it probably says what it says for a reason. So, there's that anyway. So, I guess I'm still similar to maybe where we started earlier in the evening, but Mr. Burgoyne?
Well, I was a state employee for about 30 years and worked for the Department of Human Services. So basically, the policies that we followed came down from above, be they the Department of Human Services or be the U.S. Department of Health and Human Services. And I'm very disinclined to read into law, a rule, that the legislature recently had an opportunity to review, and they did, and they decided. And the one thing I bet it's been impressed upon me is we don't make law. We don't make law. And I think to do anything else would be us making law. So therefore, I'm gonna
Kind of where you were.
I mean, where I was, and it's just complicated. It's complicated, but I think because it's far-reaching, if the legislature and the governor want to do as you requested, they certainly have the opportunity every legislative session. Doesn't have to be anything submitted by the governor or a legislator. Your representative could submit something if you want to, and they'll revisit it. And if they want to change policy, then we're happy to live with the changed policy. But given where we are and what we got, I think we're pretty well, one is not the other. One kind of trust is not the other, and that's how it is.
Great, thank you. Do we have, are we ready for a motion?
I have a motion I'd like to make.
Okay, Mr. Vice Chair.
It has multi-parts, but I think they're interrelated.
Before we do that, council, was there something else that we needed to do in the deliberation phase? We get the findings of fact, we discussed in general terms, feelings and temperature.
No, as long as it's clear what the basis of the decision is, of the decision of the board as a whole, then that's fine. And when I hear your motion.
Okay, so we're there then. Okay, Mr. Vice Chair.
Mr. Chairman, I move that the appeal of the assessor's denial of the application for homestead exemption be denied for the following reasons. Number one, The owner of the property located at 20 Savage Street, Bangor, Maine. The owners are Arthur J. Keenan and Cynthia S. Pelzar, not individually, but in their capacities as trustees of the Arthur J. Keenan and Cynthia S. Pelzar Trust of 2016, hereinafter the trust. The trust, by its terms, is an irrevocable trust. The definition of homestead in Title 36 MRSA Section 681.2 allows only those owners of residential properties who are individuals or trustees of a revocable trust as defined by Title 18B MRSA Section 103.13. Arthur J. Keenan and Cynthia S. Pelzar as trustees of the Arthur J. Keenan and Cynthia S. Pelzar Trust of 2016 do not qualify as owners under that definition because they are not trustees under a revocable trust. Arthur J. Keenan and Cynthia S. Pelzar, individually or as beneficiaries of the Arthur J. Keenan and Cynthia S. Pelzar Trust of 2016, are not owners of 20 Savage Street real estate as required by the definition of homestead at 36 MRSA, Section 681.2.
Okay,
That is the longest motion I've ever heard. But it's
I was
detailed.
struggling. That,
Didn't know
that
we
covers it,
were
okay.
out.
Seems to pass muster, so, okay, moved and.
Seconded.
Okay, moved and seconded. Is there a discussion about the motion? Council was fine.
Nope.
Okay, I don't have anything. Those in favor are raising the right hand. Okay, so, vote is unanimous. The, appeal, is denied. We will prepare a decision, likely over the next 24 or so hours. We'll be doing that, in, concert with council, so there may be some back and forth. But we should have that out, I don't know, what, end of the week?
It'll be very quick.
I think our bylaws want us to make a decision within 10 days.
Or within 10 days.
Within 10 days.
So we'll be working on that, then over the next few days.
John, do you need LD 149 to
I
draft?
would like a copy of that.
Well, we only have one.
Yeah, well, I think I know where to find them too, but,
Yeah.
okay, okay, the purpose of our hearing being satisfied, at this time then I'd entertain a motion to adjourn,
So moved.
okay? So, second, thirded, those in favor?
Yeah.
Beautiful, we are adjourned. Thank you all, for your time. Okay,